Colorado Court of Appeals. We have two cases on our docket this afternoon. The first is the People versus Guardado Rivas. Counsel, I see are present at council table. And the second case is Michelle or Michael versus the State Board of Optometry, and counsel are here for that case as well. Okay, I won't have to give the instructions more than once. First of all, my name is Judge Richmond. I'll be presiding today. To my left is Judge Greg Welling, and to my right is Judge Anthony Navarro. We will allow 15 minutes for each case. Of course, the appellant may save time for rebuttal, but there's a clock, and it's up to you to keep track of your own time. We're not going to give you any flags or anything like that. Please stay close to the podium because these proceedings are being recorded and maybe even live streamed. And we want everybody to look nice in the pictures. And also, and I don't know if this is true in the first case, if there are any issues of maintaining the privacy of an individual who's a witness or a victim, please use our initials as opposed to the name. I don't know if it's an issue in the first case or not. And finally, I want to make an announcement. You see in the court, we have a large audience in the back there. This is the 8th grade class from the Denver Academy of Torah, some of their teachers, and I think some parents. They're here today because they are learning in their social studies or English class the book To Kill a Mockingbird, you know, our favorite from 8th grade. They don't know the results of the trial yet, so don't tell them, okay? At least they didn't when I was there last week. But the idea is for them to observe what a court proceeding, at least an appellate proceeding, is like. So counsel in this in a criminal case, so counsel in this first case have very kindly agreed to meet with the students as soon as the oral argument is completed. They're going to go to another conference room on the floor, and the students will be able to ask questions of counsel about the case, and I'm warning you, they have some very good questions they did last week, so be ready. Better than our questions, probably. And they may even ask some questions about the practice of law and how you came to become lawyers and that sort of thing. So we're going to take a brief recess just to allow the students to exit after the first case. So thank you for indulging them. And with that, I will ask counsel in the first case to approach.
May it please the court, my name is Julia Chamberlain, bar registration number 47181, and I represent the appellant, Mr. Guardado Rivas. I would like to reserve 4 minutes for rebuttal. Evidence presented at trial showed that Mr. Alvarado came to Mr. Guardado Rivas's home at night while he and his wife, Ms. Solis, were sleeping. When Ms. Solis opened the screen door slightly to tell Mr. Alvarado to come back another day, he immediately grabbed her, pulled her onto the front porch, and sexually assaulted her.
This is her testimony.
According to Ms. Solis and Mr. Guardado Rivas.
Is this the, I know there were conflicting versions of events, sharply conflicting versions of events. Is this the only version to which the Make My Day statute would apply?
Well, I believe Ms. Solis and Mr. Guardado Rivas's testimony gives rise to Make My Day. Mr. Alvarado, as you said, testified very differently.
And let me kind of sharpen my question.
Sure.
You're contending that because there was sufficient evidence in the record, a very low standard for the giving of an affirmative defense, it should have been given. But are you conceding that if the version of events that the prosecution relied on, which was this all occurred in a single visit where there was some flirtation that went on, and then Mr. Guardado, the defendant, responded by punching the victim, if that was the case, Make My Day doesn't apply to that under your theory, is that right?
Well, that version wouldn't give rise to Make My Day.
I just want to make sure that that's your position.
I think it's important to discuss the evidence, though, in light of these different versions. In the reply brief, I cite Ms. Solis's, I do a table, and it's on page 20 of the reply brief. And I cite her pretrial statement as well as her trial testimony, and I show how much it actually mirrors one another. So I believe both her pretrial statement as well as her trial testimony would give rise to Make My Day. I also believe Mr. Guardado Rivas's trial testimony would give rise to Make My Day as well. And I also don't think he testified inconsistently with his pretrial statement either. If you look on the testimony from August 24th, 2015, in the afternoon, Jennifer Durio, she was the PSI writer in this case. She testified really briefly, and all she testified to was that Mr. Guardados Rivas said that Mr. Alvarado came over to pick up a bed. Ms. Solis said that Mr. Alvarado winked at his wife, and Mr. Alvarado grabbed Ms. Solis's arm, and that's when Mr. Guardado Rivas punched him once. Mr. Durio never testified where this actually occurred, so I don't think that's inconsistent either.
And I'm
Sure.
totally understand that.
Yeah.
Here's what I want you to explain to me that I'm having trouble with.
Certainly.
Assume that there was sufficient evidence that the defendant's and his wife's version of events were there to give rise to the giving of this instruction. How would the jury have rejected self-defense, but given credit to Make My Day under those facts?
Certainly.
Going to harmlessness.
Yeah, and so I discussed this in the opening brief when I'm discussing harm. There is a difference between defensive person and Make My Day that's really critical under the facts of this case.
Anything beyond the reasonableness of the force?
It's reasonableness of the force, which is really the big difference, because under Make My Day, you can use any degree of force, including deadly force, in response to what the defendant reasonably believes the victim may be using any amount of force, no matter how slight. But under defensive person, there the defendant has to use a degree of force reasonably necessary to defend against what he believes is the imminent use or use of unlawful physical force.
And that's, I guess, what's hanging me up a little bit, is if it sounds like from reading closing arguments in the trial testimony that the prosecution's argument was, if it happened as the prosecution said, which is the flirtation occurs following an invited entry and he strikes him, that's not a reasonable response to flirtation. But they don't appear to be arguing that if the events occurred as the defendant claims, that he grabbed his wife from the house and was assaulting him on the porch after returning, that a single punch to the face was unreasonable force. The only time that I read that the word reasonable is used in connection with the defendant's version of events is that it wasn't reasonable for the defendant to have taken so long to come to his wife's rescue, but never contends that the amount of force used under defendant's version of events was unreasonable. He just argues it didn't happen that way. So I'm trying to get my head around he didn't shoot him. He punched him one time in response to an assault. And how is that? How did the jury potentially reject self-defense? Basically, accept those facts but reject self-defense on the basis of unreasonable force. Can you help me with that?
Yes, I have 2 points in response to that. The first one is I disagree with you a little bit in closing argument. Direct quote from the prosecution stated, Mr. Guardado was not defending anybody in any kind of reasonable way, and there was no provocation such that it is justified that he can hit Mr. Alvarado. That's on page
110, right?
121, and it's line 19 through 21, and that's from August 25th, 2015.
And
so I think that statement is more broad.
But if you look at the context that that the defense counsel or the prosecutor appears to be making that argument, it's in connection with if it was in response to the flirtation, it was an unreasonable response. So it's contextualized that if you accept our version of events, the force was not unreasonable. And that's why I started with, did Make My Day apply if the prosecution's version of events was what the jury accepted?
Well, when looking at the closing argument, I am a little confused where the prosecution is getting this version of events, because Mr. Alvarado testified that all he did was come over, drank some beer, he was going to have a meal, he was going home, he turned around, and that's immediately when Mr. Guardado Rivas punched him. So there's no winking, there's no flirtation. Mr. Guardado Rivas' pretrial statement doesn't give rise to that version. His trial testimony doesn't, and neither does Ms. Solis' pretrial or her trial testimony. So I think that the jury could have rejected the prosecution's version of events because I don't think it's supported by the evidence. The prosecution also argued that Mr. Gradado-Rivas told Ms. Durio that Mr. Gradado-Rivas also said that, well, maybe I could have done something differently instead of punch him. Maybe I could have spoke to him loudly or stopped and thought. And so the prosecution also relied on this to show that it was unreasonable use of force.
Weren't they really relying on that to demonstrate that it was their theory of the case, that this all occurred at one time following the flirtation as opposed to on a return visit where an attempted assault transpired?
Well, under the prosecution's version, it never accepted Ms. Solis or Mr. Gradado-Rivas' version of events. So the prosecution had a different theory of the case than the defense.
But Ms. Chamberlain, I'm sorry to interrupt you. Go ahead and
Can I
finish
just
your
finish
answer.
one more
Yes,
point?
please do.
And then the other point I wanted to make is that Mr. Alvarado testified he did absolutely nothing wrong to provoke this force. And the jury rejected his testimony because they found that Mr. Gradado-Rivas acted in a heat of passion. So I think under the jury's verdict, when they found heat of passion, but they rejected his defense of person, that they found that Mr. Alvarado did something more than wink or flirt with Ms. Solis, that perhaps he grabbed him like Ms. Solis and Mr. Gradado-Rivas testified to.
But if he grabbed him after there was a lawful entry, it doesn't give rise to make my day, does it?
Excuse me, can you rephrase that again?
If the grab or of Ms. Solis occurred after, under this being a single event, if this was a single event, there was no unlawful entry, right?
The testimony, it's a little unclear. Mr. Alvarado doesn't even remember when this occurred. I don't know if it was outside or inside.
I apologize.
When they were eating their meal.
I don't want to
So-
monopolize your time. I know Judge Navarro has a question.
Thank you. I think you actually answered much of it. Just a quick follow-up. As you well know, the jury can accept all or part of each witness's testimony or some combination thereof. Is there a scenario where the jury accepted defendant's version and his wife's version, that Alvarado came back later in the day or later that evening, knocked on the door, he grabbed her, pulled her onto the porch? Let's say they accepted all that. Would that necessarily give rise to a defensive person, or in such a way that there are certain elements of defensive person, like either use of force or imminent use of force,
Yeah.
which are not required by Make My Day? So is it possible to find one and not the other, even if you believe those facts from the defendant's side of the story?
Yeah, I think it would just go to the the amount of force used in response. That's the only difference I can see between the two defenses. I don't know if I'm answering that.
Yes, thank you.
And also,
Counsel, I have a question, I'm sorry. We're gonna run
Certainly.
up on time soon. You make much ado in your brief arguing that the porch is part of the dwelling. Is it necessary for us to decide that in your favor? And if we do decide that in your favor, if Alvarado lawfully entered onto the porch, which he could have done just to knock on the door, where was the unlawful entry into the dwelling?
I don't think that you need to decide the porch if you find that there was an entry by when Mr. Alvarado grabbed Ms. Solis and pulled her outside. So I don't think you would need to reach that. I think it would be unlawful, even under the porch scenario, because Ms. Solis and Mr. Gradado-Rivas did not invite Mr. Alvarado, and he was entering knowingly and in violation of he had criminal conduct.
Well, if a person enters onto someone's porch to
Yeah.
knock on the door, I don't suppose you'd contend that's an unlawful entry at that point. And if he
Perha-
lawfully entered onto the porch, where was the unlawful entry into the dwelling in this case?
Well, if you disagree that it was unlawful when he went onto the porch, I still argue that there's an alternative argument that Mr. Alvarado unlawfully entered when he pulled her out. I do believe that porch is part of a dwelling, and I do believe that when Mr. Alvarado went onto the porch, he was not invited at that point, which is what the prosecution conceded down below, and he was also entering the porch in violation of the criminal law, because he was going there not to pick up a bed, he wasn't invited, and he was going there to perform a sexual assault against one of the occupants of that dwelling. So I do believe that it is still unlawful at that point, based on the conduct that occurred here.
And I know I'm running into your rebuttal time, so I'll try and make this quick. I apologize. Is make my day, it differs from burglary and trespass in one really important way. I want to make sure I'm right about this, in that you can commit burglary or trespass by not only either unlawfully entering or unlawfully remaining after a lawful entry. The make my day does not apply to that latter part, right? Am I correct in that?
Certainly, McNeese states that burglary and trespassing may satisfy the make my day unlawful entry, except for the unlawful remaining portion.
I just want to make sure that I.
And if there's no further questions, I'd like to reserve my time. Thank you.
Thank you, counsel. You have 2 minutes and 34 seconds.
May it please the court. Good afternoon, Your Honors. My name is Majid Yazdi, registration 36043, representing the people of the state of Colorado in this case. As Judge Welling pointed out from the beginning, we have to consider the two versions of events in this case because it affects the way the jury decided. These two versions of events are completely irreconcilable. There's no way the jury could have taken part of the version of the events presented by the prosecution and part of the version presented by the defense. I would refer to the prosecution's version as the flirtation version, and the defense version is the sexual assault version. Contrary to defendant's assertion, there is clear evidence that the version presented by the defense at trial had never been presented. The statements made by the defendant and his wife never referred to a second visit by Mr. Alvarado. And Ms. Solis, defendant's wife, acknowledged during cross-examination that she had not mentioned the return of Mr. Alvarado at all.
Certainly that is an argument that is available and was made as to why that version of events should be rejected. But that argument doesn't go to why an instruction based on that version of events shouldn't be given, does it?
A theory of defense instruction?
No. That isn't the defense entitled to an affirmative defense crafted around the testimony that was given in support of their version, even if it's in tension with earlier statements or has some indicia of a lack of credibility?
Absolutely, and in this case was given.
But
Affirmative defense.
and an affirmative defense of defense of others was given. But what about the make my day? If this occurred, that he came back, so he had already left and he returns, knocks on the door, she slightly opens the screen, he reaches in, hand crossing the threshold, and grabs her out, and then begins to assault her, and the husband then responds to what he witnesses. Why, if that is a version of events, why would that not support the giving of a make my day defense?
Okay, I will explain that, but just to preface my response is that I was not suggesting that just because there are two versions, the instruction cannot be based on one version just because the jury may reject the other version. So obviously
fine.
that's the case. But even if we accept the version, the sexual assault version, as the court ruled, the prerequisite for the make my day instruction and the statute, the elements of the make my day defense require, the prerequisite is an unlawful entry into the dwelling.
Okay. Now
And the
let's-
court rejected that
I know the
argument.
court rejected that. The question is that an error of law? If someone reaches into a home and reaches through somebody's window, grabs something, takes it, puts it in their pocket, and walks away, have they unlawfully entered the home?
No, not necessarily.
Isn't the crossing of
Be-
the
well,
threshold and
and that
an
is not-
unlawful entry?
And that is not enough, just entering unlawfully, which didn't happen here, by the way, but I will, just presume that that's the case.
You mean for burglary, unlawful entry is not enough? I'm sorry, unlawful.
Okay, I'm going to read from the statute to make my argument. The statute requires the make my day defense requirement is that a reasonable belief must exist that such other person has committed a crime in the dwelling in addition to the uninvited entry. So you have to have the unlawful entry, and you have to have the commitment of the crime in the dwelling.
Well,
So
But-
if
but-
the
no.
porch is not part of the dwelling, and the only act is pulling the victim out and committing the crime on the porch, you still don't have the make my day requirements present in this case.
So I didn't see that argument in your answer brief. As far as I could tell, your answer brief, like the trial court's order, addressed only one element of the Make My Day statute, which is whether there was an unlawful entry. And if the court was wrong about that, and if we disagree with you about that, shouldn't we reverse? Because you did not address any of the other elements in your brief.
Well, I addressed the unlawful entry.
That's one
yes.
of the elements.
Yeah, and the
But
court
now
did
you're
not
talking
address
about-
dwelling because the dwelling was not even presented to the court as an issue.
Right. Well, all the elements have to be satisfied in order to get.
And that's why
In
I
your
think-
answer brief, you chose to only address the first element, which was the same element the trial court did, which is whether there was unlawful entry. You did not address whether there was a reasonable belief that the other person had committed a crime or that there might be physical force used.
I
You
think I-
put all, well, I didn't see it in your brief, so if you could point it out to me, that would be great.
I
then
argued
maybe I
that
missed it.
the defendant didn't have any reasonable belief that there was an unlawful entry to begin
Right,
with.
that's the
Yes,
first element.
yes.
Yes, you did address the first element. I didn't see that you addressed any other element besides the first. That's my question.
Again, if the court's ruling is that there was no unlawful entry into the dwelling, I just supported the court's argument based on the evidence.
Right, and you didn't go any further to address the other elements, is my question. Which is maybe, I understand your views, you didn't need to, so but I'm not asking you whether you should have or should not have. I'm asking whether you actually did.
Yeah, I just wanted to respond to Judge Welling's point that whether that would qualify as a requirement for Make My Day, and I say that it does not qualify.
Let me ask
Because
you-
it does not meet the statutory requirement that a crime be committed in the dwelling
Thank
as
you.
well.
What does not?
The pulling out of the victim, the defendant's wife, and then committing the crime on the porch.
Pulling her from inside if you take her version of the events, pulling her from inside the house out onto the porch where he assaulted her is not committing a crime in the dwelling.
In the
addition,
dwelling.
Reaching in through the door and pulling her out is not a crime in the dwelling?
If the porch is not part of the dwelling, based on that, it's like taking the victim to the street and committing the crime on the street.
But if the
Then
porch
it
is
is not.
if the porch is part of the dwelling?
Yes,
That's
of
the question
course.
I asked counsel before.
Let's assume the porch isn't part of the dwelling. Let me give you a hypothetical.
I'm sorry, isn't or is?
Is not.
Okay.
Okay. Let me give you a hypothetical. You're here defending a conviction where what happens is the defendant went to somebody's home, knocked on the door. While the victim was inside, the defendant grabbed the victim, pulled her out of the house, moved her, and then assaulted her. The charges in the case and the conviction that was returned was for burglary with a breaking and entry and the crime being assault and kidnapping, because there's also asportation. Would you be here defending that conviction as having sufficient evidence to sustain a conviction for those two charges under these circumstances?
I think the burglary conviction would be problematic because the crime has not been committed in the dwelling, because that is a requirement of burglary.
Assume that there was no assault that occurred. Fine. Assume that it was a grabbing and just forcible pulling out of the house against her will.
Then assault would have occurred inside, yes.
Isn't this then a crime of assault under their facts occurred inside the dwelling and an additional crime
The
of
sexual assault didn't occur.
That's fine, but if assault occurred, that's enough, isn't it?
That was not the charge.
What do you mean?
No, I mean, that was not the claim. That the claim was that the defendant, first of all, defendant also must be aware of that. So even if there's pulling out of if there's a crime there, we are talking about the defendant using the statutory defense, Make My Day. So he has to have a reasonable belief that there is a crime committed in the dwelling. So
Isn't
if
that a
the
jury
assault
question?
occurred, if I can finish, if the assault occurred by pulling out, that may be a crime that Mr. Alvarado can be charged. But the defense of make my day cannot be applied here because defendant was not even aware what happened. According to his testimony and the wife's testimony, they realized, defendant realized that there was a screaming and came to the porch and then saw the assault, sexual assault, occurring on the porch. So that does not even justify the scenario that, it would not be consistent with the scenario that you're referring to because it is a different crime and a different defense would apply to that.
But statute, when the occupant has a reasonable belief that such other person has committed a crime in the dwelling, the grabbing of his wife was a crime in the dwelling. And what he knew and when he knew it is a question, I think, for the jury. And then, and when the occupant reasonably believes that such other person might use any physical force, no matter how slight, against any occupant. So doesn't he, there's an ongoing use of force against her.
The question is whether the defendant had a reasonable belief that there was a crime being committed in the dwelling. My point is that if we assume that the porch is not part of the dwelling, if the crime is being committed on the porch, defendant cannot use make my day defense. He can use defense of a person, which was done and was rejected by the jury. And I would go back to your argument that there's no way that the jury could have rejected a defense of person and accepted the make my day because the essence of that was the version of the events presented supporting that defense was rejected by the jury.
But that's a harmlessness question, not
Yes.
a question of
Yes.
whether there was error, right?
Correct.
Why couldn't the jury accept part of the defendant's version and reject others?
They're irreconcilable.
Well, let me test that theory. Why couldn't the jury say, well, we believed you, defendant, that Alvarado left, then came back at night, knocked on the door. His wife, the defendant's wife, went to answer the door. Alvarado pulled her out onto the porch. But then the notion that he actually sexually assaulted her, the jury didn't go that far, couldn't believe that much had happened. Simply believed all he did was pull her out onto the porch and harass her in some way, but not enough that would be sexual assault that would justify defense of a person. Why couldn't the jury believe that?
There was no claim that there was no sexual assault. It was.
Right, but the jury doesn't have to believe there was one just because nobody claimed there wasn't.
No, but there's no alternative to that because the only claim made by defendant and his wife is that there was sexual assault. There was no other evidence to say that, okay, there was no sexual assault, but there was an assault because there was no evidence that there was an assault.
Well,
there was only evidence of sexual assault.
Well, I'm not sure that's true. She testified about him grabbing her, about him maybe knocking her over. Those would not be, that wouldn't be sexual assault by itself, and the jury could believe those happened, but not the later sexual touching.
Mm-hmm. And the jury, by the way, just to add to that, as I have argued in the brief, the jury could not have believed that there was heat of passion and as a mitigating circumstance, and there was sexual assault or even assault, because when the scenario is that somebody is being attacked, assaulted, or sexually assaulted, that doesn't create the context for provocation and saying that, well, whether there was heat of passion or not, whether there was time to reflect or not, that is obviously a case of defending the victim. So there's no way that heat of passion could have been applied, could have been used by the jury as a mitigating circumstance if the scenario is what you just described.
Well, no, because you're assuming the jury had to believe everything the defendant said or nothing, and I don't know why we have to take such an all or nothing approach.
Well, because there is no, if you're distinguishing between assault and sexual assault, or the two versions between the
No, it could have been
prosecution?
sexual assault, it could have been assault, it could have been some other act that was simply highly provoking, but wasn't an assault. There's all sorts of different things that could have happened which fall into those different categories, and why does the jury have to believe everything or nothing?
Well, again, because there is no evidence that there could have been something less than sexual assault if we go with the defense version.
That's
There was
assuming,
nothing-
well, again, I guess we're going in circles. That's assuming that the jury has to believe everything the defense said rather than only part of it.
It is true that the jury may not completely accept every aspect of the version, but the essence of the crime, the essence of the reason for defendant's action is that the victim had been sexually assaulted. There was no other version presented to the jury. So
There was another version presented, and it was used to impeach the wife, that when she initially reported, she didn't report a sexual assault, but merely an assault of some sort. So there was some non-sexual assault version that was argued to the jury as having been a prior inconsistent statement, right?
that would be the flirtation version, which I argued it's completely irreconcilable, because if you believe that version, then there's no second visit by Mr. Alvarado to even justify the.
The two pieces of evidence that we do potentially have that would allow for heat of passion, but not make my day, or not defense of others, is both it wasn't a sexual assault, it was something, it was a lesser attacking.
Like flirtation.
Or something along those lines, but having accepted that it occurred a second time, or on a second visit, and the defendant's statement to the parole officer, or the probation officer, indicating that he gives this sort of admission that maybe he used more force than was necessary. I mean, what if they're accepting his version of events as to when it occurred, i.e. a second visit, but also accepting that he admitted that he could have used lesser force?
That's exactly my point, that testimony or that statement can only make sense in the context of the flirtation.
Counsel, your time is up. Thank you for your argument.
Thank you very much. We ask the court to affirm the court,
Thank
the
you,
defendant's conviction. Thank you.
Would the clerk add 52 seconds to counsel's 2 minutes and 34 seconds? Since we went a little over. Thank you. Okay, proceed.
Thank you. Under every version of story that Ms. Solis and Mr. Guardado Rivas told, either before trial or during trial, it always included some act of Mr. Alvarado grabbing or hugging Ms. Solis and him punching Mr. Alvarado after this occurred. None of their versions included Mr. Alvarado simply winking and blowing kisses at her. So,
Where did Mr. Guardado see these events that you just described happening? He didn't see them in the house, did he?
no, Mr. Rio never testified to that, but
So then the prosecution's point is he could not have had a reasonable belief that the other person was committing a crime in the dwelling, in addition to the uninvited entry, unless we conclude the porch is part of the dwelling.
Well, in cross-examination of Mr. Rio,
I think that's his point.
defense counsel asked Mr. Rio, did you ask where Mr. Guardado Rivas hit Mr. Alvarado? This is on page 52 of the August 24th, 2015 PM testimony, and she said she didn't. So there's no indication where this assault occurred based on his pretrial statement.
But Guardado didn't testify that he saw the victim assaulting the wife within the house.
He did. He testified to that.
Within the house?
He testified that not within the house, not the sexual assault portion. What he testified to was that his wife told him she was just going to go to the front door to tell whoever came to leave because they were sleeping. She was in her pajamas.
Okay.
He heard her screaming about 4 times. He got dressed, he got to the front door, and he saw the sexual assault on the front porch. He also testified that he believed that something worse was going to happen to Ms. Solis and that perhaps Mr. Alvarado was about to rape her. So that's when he ultimately punched Mr. Alvarado in the face.
But where was his reasoned belief that Alvarado committed a crime in the dwelling? Only if Alvarado committed a crime on the porch, and the porch is part of the dwelling.
Well, I believe it's a reasonable belief standard, like you said. So I think the screaming, knowing that she was just going to the front door, she was in her pajamas, she wasn't going outside, she's screaming for help. And so I think that based on that, testimony alone gives indication that a crime had occurred in the dwelling,
He could have a reasonable belief that he pulled her out of the door even though he didn't witness it.
which would be a second-degree kidnapping. I also believe that his testimony gave rise to Mr. Alvarado believing that there could be a crime committed in the dwelling because he testified he thought something worse, such as a rape, was about to occur. So I think based on all that testimony, that satisfies that prong of the Make My Day test.
Counsel, I noticed in your opening brief you have a definition of porch, which has the definition you give is a covered area, usually having a separate roof. Is there any evidence that this roof was covered or that it had a separate roof?
There's no indication that it's covered, but I think the most important part for the Make My Day statute is whether it's adjoined, affixed to the house, because a building under Jimenez says that you can't exclude any portions of the building for dwelling. And may I complete my answer? And there's testimony that this porch did adjoin the front door. Mr. Guardado Rivas testified that Mr. Alvarado left the porch after the attack.
Thank you.
So thank you.
Counsel, thank you. Thanks to both counsel for your fine arguments. The case will stand submitted, and opinion will be issued in due course. As I explained to the students, we're not going to announce our decision today. It's not television. We'll write it up, we'll mail it out. Counsel are excused, and we're going to take a brief recess while the students adjourn to a conference room to meet with counsel. So the clerk may announce just about a 3-minute recess.
All rise. The court will be in recess.
Our second case on the docket is it pronounced Michelle or Michael?
Michael, Your Honor.
Michael. Michael versus the State Board of Optometry. Counsel were present for the earlier instructions, so without further ado, you may proceed. Please be seated. You may proceed, counsel.
May it please the court, my name is Hugh McNulty. I'm an active member of the Colorado Bar, and my bar number is 012993. This case is Michael versus the State Board of Optometry, and it is a direct appeal from a final order of the board, which in turn confirms an original order by an administrative law judge, which in turn granted a motion of summary judgment revoking a license that Mr. Michael, Dr. Michael, had in place. It happened to be an inactive license, but that involves some complications, which I think are discussed in the brief.
It was inactive when the board revoked it?
It was an inactive license. Your Honor, there were two time frames, and
I was going to ask about the second one. It was inactive when the board revoked it.
yes, sir.
It was active, according to the appellant, when he checked off the box or submitted the paperwork that said he had completed his continuing education requirements.
You're right, Your Honor, in the sense that he had executed the form that the board provides, and it does not provide, unlike the Bar Association, when you go to renew, it does not give you a form which allows you to opt for inactive status. It was a crusade of his to get the closing of his practice and his opting for inactive status recognized by the board.
It doesn't give him the option to check off a box that says inactive, but it does give him the option of not submitting it at all if he's not active.
I understand that, Your
I mean,
Honor.
is that-
and
is that
we're
correct?
prepared to agree that perhaps he was over-anxious. The other part of it is that when it comes time for you to do an inactive application, it can be more difficult, and it involved a time gap. He got impatient. It's simple. It's human. He notified the board that he wanted to be on inactive status. That was done to Ms. Lucero in December of 2012. And he waited and waited. She told him to send in a letter, and they would send out the appropriate papers. Never happened. And so he went ahead and executed the active renewal form. We acknowledge that. But on the assumption that he had communicated, and in fact, he was not in active practice at all.
But don't those contentions of having been over-anxious and submitted an active renewal while checking the box, doesn't that go to sort of the level of scienter or the flagrancy with which the violation was committed? In other words, it mitigates the nature of the violation, but doesn't necessarily go to the question of whether there was a violation.
Well, Your Honor, if I may sidestep, on the form, it said, I hereby attest that I am in full compliance and whatever of any of the requirements that are applicable for an active renewal, the ones that were required. He was in inactive status and interpreted the term required as not applicable to him.
But I thought, in fact, his license was active. I mean, even though he wasn't practicing, It was active because he had not filled out an application for inactive status.
It's confusing, Your Honor, but the way the time sequence works, which I've outlined in my brief and also the motion to dismiss, was you're active, and then there's an upcoming period in which you will elect in March to become, you elect in the January to March period to become active in the March to the next 2-year period out. He gets the form and executes it, and by that time had stopped practicing. The rule of the statutes at 1270-101 says anybody who is in inactive practice does not have to satisfy the continuing education requirements.
So if he believed that, why did he submit it? That's what I don't understand.
He was impatient. Forgive me, Your Honor. I don't mean
You
to
said, yeah, I know,
get testy,
impatient,
but
impatient for what?
he wanted to keep.
I mean, what he seemed to do is he fell into a bit of a trap. He sort of had did he have a Hobson's choice that he had to go, he had to submit it or not submit it?
I
It doesn't
can't do
sound like-
better than that. It's a trap. The way the system at the board is set up is not, let's say, user-friendly, the way the bar is. We say either inactive or active. You do it. For him, he was in inactive practice. We're talking about psychology. He has spent a lifetime practicing ophthalmology and wanted to hang on to some evidence of his licensure. And so what he did was he took the steps to contact the board. And as you have seen from the briefs, the contacts went on and on and on and on. And with absolutely no help from the board to convert to inactive status. I think overall the record shows that he was acting in good faith, and that's all he should be held to.
And if he was acting in good, but he applied for and received an active license, right? A renewal of an active license, right?
On paper,
Yes, which is your argument of good faith goes to sort of a mitigation of his culpability. Doesn't that go to, not to whether he violated, whether there's a technical violation, but to what sanction should be imposed?
no, I think, well, they're related, obviously. If the court finds that this was a severe thing, and in fact, when we talked about the Farmer case, which you asked me to address, I think we'll touch on this same issue, which is why should a person's professional status be revoked when he's trying his darndest to comply? He's not doing anything in substantive violation of the things that the board is most concerned about, illegal practice. And he made a paperwork. He filed the form. There's also a technical argument that the representation that has been claimed by the board as the ground for the violation is a representation that, forget about it, whether it's the active form or not. The representation says, I have completed all of the CLE or CE requirements that are required under the law, as I've set forth in the briefs. He was not, as an inactive practitioner, if that's it's an oxymoron, he was not obligated to do any more than he had. He had done something like 19 hours, and they required 24 for the active. But it was over for him. He had stopped practicing. He gets the form. They didn't send him the form, and they didn't help him in any way to convert into inactive status. So he gets the form. It's very human. He just wants to get it done. So he fills out the form. He reads the bottom line. It says, I've completed all of the CE requirements that are required of me, because they weren't.
Because he didn't think they were.
No, the statute.
If he's inactive. but
I
he's-
don't know that he went to the law library and looked it up, Your Honor, if that's basically,
Let's try this. Assume that what we conclude is that his intent and what he thought and why he did it is not material to whether there was a violation. The only material facts as to whether there was a violation was whether or not he submitted an application consistent with applying for an active license and affirmed something that was not true for an active licensee. Therefore, there's a violation.
but Your Honor,
And is there any-
as you well know, this court is under the obligation to consider the record as a whole. We'll get on to the questions that you kindly directed to me. And the record as a whole demonstrates that it wasn't that he was in active practice or intending anything. There are competing pieces of information, of evidence that suggests he was in active practice. The board had been notified at least 8 or 9 times that he was in active practice. The board did nothing to help him straighten things out or convert. And I submit that taking the record as a whole means that his efforts show that there was no violation and nothing was intended. I know he didn't go to the library to look up parts that were required, but that's what the standard was, and he had complied.
The statute doesn't require an intentional violation, does it?
No.
You want to go ahead and maybe turn your attention to the questions? If you had something to say about that.
Forgive me. I had thought, if it's up to you, if it's acceptable, I thought I would, after our initial discussion, I would talk about the questions you addressed in the letter, and in particular, the impact of the pharma decision, which I loved the word inform. I thought that was wonderful.
Counsel, before you turn to farmers and our questions, you didn't cite farmers in your opening brief, did you?
I did not.
You didn't cite it in your reply brief, did you?
I did not, Your Honor.
And you didn't make an argument in your opening brief that the discipline imposed by the board was arbitrary or capricious, did you?
I did not. That was because I believed that it was flat out illegal.
But you didn't say that
That's
in the opening brief, that it was
I know,
arbitrary or
Your Honor.
capricious. So the farmer criteria would say, perhaps, I'm going to paraphrase it, perhaps the board should have considered a lesser discipline wasn't raised in either of your briefs.
I gave my request for relief, I stated in descending order, a request that the court dismiss the matter entirely or remand it for a hearing. I think that's consistent with Farmer, although I am prepared, if you will permit me, to say a few words about Farmer and informed.
You can say it, go ahead. I'm just pointing out that I don't see it in your brief.
No, it isn't there, Your Honor. And by the way, I'd like to thank the court for directing my attention to Farmer. The significance of Farmer is, and how it informs the present case, it's a classic, Farmer was a case where it was a paperwork problem. The hunting guide failed to renew his license in Colorado, and he got hung out to dry for a complete destruction of his career, 20 years suspension. I think that was classically a case, and the court felt that, of overkill. And it wasn't as though he was going out and leading tours where they were massacring mountain lions in violation of the real concerns of the Wildlife Board. The same thing here. We have a technical violation with the submission of the active form, which was the only form he could submit, and it was a technical violation. In the meantime, he is screaming his lungs out to the board. Somewhere I have it on my list. There are 8 or 9 times. Here it is. Voila. from the first telephone call to Lorraine Lucero until the date when the notice to set occurred, there are something like 8 communications, telephone calls, emails, letters, none of which were responded to. So, I mean, I think in terms of what Farmer stands for, Farmer stands for the triumph of literalism over the substantive concerns of the agency. Same thing here. We basically, yes, it was decided that that he had misrepresented on the form, although I've contested that he had completed the necessary CE for nobody called him up. And the simple thing, I remember this from a moot court thing I had when I lost because my opponent said we could have sent him a postcard. In this case, they could have driven out to the Costco on Quincy and seen whether he was there, because he wasn't. It seems to me that that was incumbent on the board as part of its investigative duties.
Counsel, your time is up. We thank you for your argument.
Thank you. I'm sorry if I became emotional, but this has disturbed me.
Thank you, counsel.
Thank you, Your Honors.
May it please the court. My name is Jodiana Haskins, number 41285, here on behalf of the State Board of Optometry and the board members listed in their official capacity. As the court issued its recent order, posed a number of questions to the parties, and I'd like to jump right in and address those questions right off the bat.
Can I ask one factual question?
Sure.
When I looked at the ALJ's order, she said that the doctor had submitted applications both in 2015 and 2017?
Yes.
This actually happened twice?
Yes.
And on both forms, he listed himself as active?
Yes.
And on both forms, he listed himself as having completed the continuing education requirements?
Yes.
In both cases, the latter wasn't true?
Correct.
Okay.
The court first asked the parties to address the appropriate.
Actually, before we
Sure.
apologize.
No.
But the notice of violation that went out, did it pertain to both applications or just the 2015 application?
Both applications.
Okay. Now, sorry.
No problem. The standard of review which the court should apply to a grant of the agency's grant of summary judgment. And I wasn't able to find any Colorado case law directly on point, but the 1st, 5th, 6th, 7th, and DC circuits have all held that the matter should be reviewed under the deferential standards of the APA and not de novo, as has traditionally been the case if a trial court would grant summary judgment.
What's the rationale for any level of deference in a summary disposition, given that they haven't actually taken any evidence?
The courts that have addressed this issue have held that the absence of a hearing does not change the standard of judicial review of administrative decisions set forth in the APA, and also noted that agencies are given more decisional latitude than trial courts as a result of their expertise. The court has also asked in whose favor inferences may be drawn from the undisputed facts. And in this case, this court has held that it is the agency that has the task of weighing evidence and resolving any conflicts. If inferences to be drawn from the evidence are conflicting, the agency's choice between two fairly opposing views may not be replaced by a reviewing court. However, in this case, the only inference that can reasonably be drawn from the findings of fact, which are set forth in both the initial decision and then adopted in the final board order, are that Dr. Michael violated the Optometry Practice Act because he failed to complete the requisite CEs, but falsely attested to having done the same on 2 separate renewal applications. This court has held that it will accept an ALJ's findings of fact unless they are clearly erroneous or unsupported by evidence in the record.
But that's because the board is in a better position than a reviewing court because they saw the parties and assessed credibility. Here, it's summary disposition. So isn't the price of adjudicating this on a summary basis that they need to and not having a hearing, that they draw inferences in favor of the non-moving party, and that they're not to be accorded some deferential weight because why are they in a better position than a reviewing court when it's on a summary adjudication?
Well, in this specific case, to this day, Dr. Michael doesn't challenge the findings of fact contained in the initial decision or the FBO. He doesn't contend that he did not complete the continuing education. In fact, he says he did not complete it because he claims he wasn't required to because he wasn't actively practicing, which is not what the statute holds. He also does not contend that he does not dispute the fact that he falsely attested to having completed those applications and instead cites to some paper problems.
Right. So that all goes to the question of whether there was a violation. Is the question of whether there was a violation versus the sanction to impose, are those separable questions?
No.
Well, okay, why not?
So the question also posed by the court, of course, was whether or not Dr. Michael was entitled to a sanctions hearing after determination of violations of the Practice Act. And I would argue that he was given a sanctions hearing. During the OAC process, Dr. Michael never challenged the board's sought revocation of the notice of charges. Dr. Michael never challenged that.
The board sought discipline up to revocation.
Correct. Revocation and/or other discipline as may be appropriate, I think was what was phrased.
Right.
And so Dr. Michael had the opportunity to argue the propriety of the sanction during the OAC hearing and chose not to.
Well,
Excuse me, counsel, where was the hearing?
So a hearing, it was held at OAC. In the administrative context, a hearing is defined as any setting in which the parties, or which an affected person presents arguments to an agency decision maker.
And where does that definition come from? I didn't see it in your brief.
Black's Law Dictionary.
So it's not in your brief, and
No,
it's
sir.
not in the statute either. The 24-4105 is the statute that governs the conduct of hearings, and that talks about the proponents will have the burden of proof, every party has the right to present evidence, cross-examine, argue. That's the hearing that's in conformity with the rule of 24-4105. Where did that happen?
So what 24-4105 says is that you're entitled to an opportunity to be heard, which satisfies due process requirements, and then it does say hearing. Nowhere does it say that a party is entitled to an evidentiary hearing, where parties appear in a courtroom and present oral arguments and witnesses and evidence. What it says, I'm sorry, go ahead.
Subsection 7 of 24-4105 says, the proponent of an order shall have the burden of proof, and every party in the proceeding shall have the right to present his case or defense by oral or documentary evidence, to submit rebuttal, et cetera, et cetera.
He submitted his case by documentary evidence in regard to the response to the motion for summary judgment.
And what about oral evidence?
Oral evidence wasn't necessary because there was no dispute as to any genuine issue of material fact.
So that would be a reason not to have a hearing. It wouldn't mean that a hearing occurred.
Well, Dr. Michael has never argued that the sanction of revocation was improper in and of itself. He has also never argued that the board doesn't have the ability to revoke his license for any violation under 1241-18-1, which is the unprofessional conduct under the statute.
But
So-
the premise, see if I'm right about this, the premise of your argument in your briefs and today is that he did get a hearing, but you don't dispute that he had a right to a hearing.
No, he had a right to a hearing as that is defined.
Okay, so you agreed that he had a right to a hearing?
Sure,
So your only point is he had one?
yes,
Okay.
twice.
Okay.
Once
So
in- go
if we
ahead, sorry.
disagreed with you that he actually had a hearing, that would be a problem here, because you agree he had a right to have one.
It would be a problem in that it would be a slippery slope, because what you would be finding, therefore, is every party is entitled to an evidentiary hearing, which would effectively mean that every licensee who disputes discipline could come before an administrative tribunal and make arguments, present witnesses, and documentation, even if there is no genuine issue as to any material fact. That would render any motion for summary judgment or any motion to dismiss unconstitutional.
No,
Licensees,
I think it would just render it contrary to the statute if the statute requires a hearing.
it requires a hearing, but not an evidentiary hearing.
It says an adjudicatory hearing. How do you adjudicate facts without evidence?
Documentation.
That's evidence.
Sure, but that was presented via motion in this
Okay.
case.
Okay. So what statute requires a hearing, in your view?
The APA entitles a party to an opportunity to be heard.
So do you have a statutory cite for me?
I believe it's 24-4105.
That talks about the conduct of a hearing, if you're entitled to one by statute. What statute entitles them to a hearing in the first place?
I believe it maybe it would be 24-4104.
Okay, thank you.
You're welcome. The court has also asked whether or not the board can summarily impose sanctions under 1241-19-1I. And the board has the right to summarily suspend a licensee if certain determinations are made. If the board were to summarily suspend a licensee, of course, a post-deprivation hearing would be awarded.
That requires some sort of public health
Sure.
risk, and you're not contending that that's present here.
No. But that under 1241-19-1I, that is the only instance in which a board can summarily act, summarily suspend. This court has referenced summary revocation when describing what has occurred in this case. And that is not what happened. The word summary implies that the board took action without the usual formalities. And that's not what occurred. What occurred was the board made these determinations based on evidence at the board level where Dr. Michael was given notice of the audit and then had an opportunity to provide evidence that he had in fact completed the continuing education. He admitted that he did not complete it because he claims he was retired. In polling the applications, which Your Honor mentioned earlier in the argument, it was discovered that he had in fact attested to having completed those CEs on 2 separate occasions. The board imposed discipline. Dr. Michael disagreed. He requested a hearing. Notice of charges was filed. A hearing was afforded, albeit via motion, and then when summary judgment was granted and Dr. Michael did not agree with that result, he engaged in the exceptions process, which also is his right. The board and Dr. Michael both submitted briefs for the board to review, and a final board order was issued. So there was no summary revocation in this case.
Explain to me what the rationale was for revoking instead of imposing a lesser discipline. I can't find any reasoned explanation anywhere in the record as to why revocation was what was imposed.
So the 1241-19-1AI is what sets forth what the board can do. It lists probation, suspension, letter of admonition, revocation. And it says that those are available to the board if it finds that a licensee has violated any provision of 1241-18-1. In this case, the board determined that Dr. Michael had violated 2 provisions of that statute. And they decided to heed to the recommendation of the ALJ that revocation was appropriate. There is no documentation in the record as to why that specifically occurred. It is the board's right to revoke a license for violations of 1241-18. Obviously, go
Why
ahead.
isn't that arbitrary and capricious then? I mean, they just, if you look at the motion for summary judgment, as best I can tell, all the motion for summary judgment said is, we think that there's no material facts as to whether or not there was a violation. Therefore, we ask for summary adjudication and the imposition of discipline. They didn't even ask for revocation in their motion. Then the ALJ goes through the process of explaining why there are no material disputed facts as to whether or not there's a violation, and just then concludes without explanation that therefore recommend revocation.
There is no there's no requirement that the board explain itself with regard to what penalty it decides to impose. A court cannot substitute its judgment for that of an agency as to what a reasonable penalty may be, nor is the power to modify that penalty granted in 24-4-1067. If I talked about the reasons behind a revocation, I would be speculating, which I'm happy to do if the court would like me to, but it doesn't appear in the record, and I don't want the court to misconstrue my argument that what I would say is somehow reflected in the final board order, because it doesn't say we find revocation is appropriate because X, Y, and Z.
So why isn't that just the height of arbitrary and capricious with respect to the imposition of the most severe penalty, and particularly on summary judgment?
Well, it should be noted that revocation, of course, is a severe penalty, but it's not permanent. The statute does allow anybody who's revoked to reapply for licensure within 2 years. So
Not within after 2 years.
after 2 years, sorry, yes, after completion of 2 years, you can reapply for licensure. And I believe what your question is going to is the applicability of Farmer, which was briefly addressed by my co-counsel. And of course, Farmer dealt with a very different statutory scheme than what is present in the Optometry Practice Act. As my counterpart argued, it said a conviction, and then it said you can, suspend anywhere from 0 to a lifetime, which this court deemed was arbitrary and capricious. But that's not what the statute says in the Optometry Practice Act. And in fact, the commission in Farmer argued that this court instead should apply the analysis in Kibler v. State. And this court rejected that because the statutory scheme was so different. The Nurse Practice Act, which was what the subject of Kibler v. State was, is nearly identical to the statutory scheme in the Optometry Practice Act. And so it follows that for the same reasons this court rejected the applicability of Kibler in Farmer, it should apply Kibler in this case. The Optometry Practice Act provides the board with discretion to address the varied degrees of culpability associated with the listed misconduct. Dr. Michael knew, as an optometrist, that if he violated any provision of 1241.18.1, that he was subject to the discipline outlined in 1241.19.1ai. It was fair notice to him that that could happen.
Where's the analysis of the varying degrees of culpability here? It really is just, there was a violation and boom, it's revocation without explanation of any level of culpability. And to the extent that evidence was submitted to the board by the doctor, it was, maybe it didn't really materially contest whether there was a violation, but it did contest the culpability. And if you draw inferences in his favor, as you might argue that you should on summary judgment, why doesn't that dictate against the imposition of this severe sanction under these circumstances without explanation and without an evidentiary hearing?
The potential mitigating circumstances which were addressed by Mr. McNulty in his argument were not presented to the OAC. All that was presented to the OAC was that Dr. Michael argued, I informed the board in December 2012 that I was retiring. It wasn't until the motion to dismiss was filed on the day of the exceptions hearing that all of these arguments about his efforts to contact the board were made in an effort to arguably mitigate the sanction. The board considered all of that despite the fact that it was not properly raised at the OAC level. In addition, all they are statements. There is nothing in the record about any phone calls, any letters that were sent. The only letters in evidence are the August 2015 response to the audit, in which he says, hey, this doesn't apply to me because I told you guys I was retiring. Even giving Dr. Michael the benefit of the doubt that he sent that letter in December 2012, of which there is no record, him telling staff that he was retiring doesn't mean anything. The statute doesn't say retired or active or actively practicing. It says inactive or active. There are many optometrists who are retired who maintain an active license for any number of reasons. So even giving him the benefit of the doubt of the arguments presented at OAC that he notified the board that he was retiring, it's not a material fact. And any mitigation that may have been brought forth by the arguments contained in the motion to dismiss presented on the last day possible, which was the day of the exceptions hearing, the board considered those. I believe my time is up. Thank you very much.
Thank you, counsel. Your time is up. The case will stand submitted. An opinion will issue in due course. That completes our docket for the day, and the bailiff may announce a recess. Thank you.